Okay, good morning, everybody. Paul here. Hold on a second. Let me get. Okay. Okay. My wife had her laptop on, and there was an echo. Still, Amy, turn this off. There's still an echo. So give me about 10 seconds, and we'll get going. Just close the window. All right. So, a lot going on here. This is just the start. I feel like everybody should have an opportunity to get all of this information, get informed. These are important decisions that you're making for yourself and your family. So I'm excited to share a lot of information really over the next 20 days. I made a decision. I was trying to figure out what to do. And then this kind of 20 presentations in 20 days, we're in the year 2020, just seemed to make sense. So really the format is today's going to be a broad overview. Great for people who just want to have just a broad understanding of some of the or most of the estate planning topics that people deal with when they try to protect what they have for their family. And then over the next 19 days, we'll touch on specific niche topics, do a little bit of a deep dive in each of those topics. The idea of doing this on YouTube, I really like the idea of doing it as a YouTube live presentation for a bunch of reasons. One, there's a chat box that I'm going to glance at and see if there's any questions. So really, you can ask me anything, and I'm going to, if it's an appropriate question, I'm going to do my best to answer it. Sometimes people ask questions and they're in context of a greater set of circumstances, and so sometimes it's hard for me to get right to the point that they're trying to address, but I'm going to do my best. By the way, I'd like to start out every presentation with a joke, and today's, boy, it's pretty weak. I get accused of having a lot of what I've learned they call dad jokes, and really this is one right there. In case you didn't see it in the chat, what happens to a frog's car when it breaks down? It gets towed away. Kind of a bad joke, but I'm gonna start every presentation with a joke. If you got any other ones, feel free to throw them in the chat. We can't have enough humor these days. Okay, so how long we'll go? I don't know, maybe we'll go 30 minutes. Maybe that's kind of the average from day to day, but I would like to give you a lot of really, really good information. I live in Louisiana. I know we already have Wyoming in the house. We have other states. I would say, if I had to guess, maybe 90% of the material that I present works and is appropriate wherever you live. And I'm going to try to point out if there's some Louisiana-specific issues. I'm going to point those out, and those might be roughly 10% of the material. But even as to that material, what might be a Louisiana-specific issue, it may be the same where you are, or it may be different. Okay, so good morning again out there. And so today is an overview. We've got today, overview, next 19, specific niche, dive in. I'm going to dive in a little bit on a bunch of different issues today. So it should be fun. If you got questions, throw them in the chat. Tell a joke, ask a question, keep it positive, and the beauty of YouTube here is that these presentations get recorded by YouTube, and then it goes up on YouTube's website. So if you want to see one in particular and you can't make it live, I think it takes about a day or so for YouTube to record it and do whatever they do and post it, on the public youtube.com website. So even if you miss it, that's probably the main reason why I use this YouTube Live for platform instead of Zoom or Skype or one of those others that I could be using where you don't get both the recording and the search. Okay, so with that in mind, let's get going. So this one, ideal. I feel like this is the person who maybe they've never engaged in any kind of serious estate planning before. They've never really had an in-depth conversation with a lawyer like myself about what they're going to do for their family and how they should do it. this YouTube live presentation is going to be ideal for those folks. So the first thing I'm going to do in this YouTube live presentation, I'm going to share with you the 8 most common objectives that people tell me that they have when they want to get an estate legal program in order. And then I'm going to dive into each of those 8 just a little bit, enough to kind of whet your appetite to really set you up for the next 19. And then I'm going to introduce you to the next 19 topics, dive in just a hair, so kind of whet your appetite for what's coming up over roughly the next 3 weeks. Everyone will be at 10 a.m. Central Time, so you can set your alarm, do whatever you need to do to make sure, make sure everything is ready to go. Okay, so I'm going to start with, since this is a big overview, I could get into the definition of estate planning is, but that's kind of blah. It's kind of way everybody else does it. I'm going to jump right in, and I will tell you, and I've sat down with thousands of people, and make sure, I always like to do a little sound check. If you can hear me okay, just type "I can hear you" or "sounds good" or something like that in the chat. And that way I'll have some peace of mind that my little microphone that I have is working and you're picking up the audio. Okay, I can see the video on the screen. So perfect. Thank you very much, Tresson. Okay. So I'm going to jump in by really giving you practical information. I have sat down with many thousands, been doing this for 29 years, and have sat across the little round table or across the desk or across the table with thousands of individuals, couples, families, and I have been fairly successful at pulling out of them what worries them. So I'm going to jump right into what the most common answers are when I ask people, what do you want to make sure gets addressed as we, sit here and talk about putting a legal program in place to protect what you have and make sure that your loved ones, your survivors, your family is taken care of the right way. All right. Back at you, California. Boy, it's early, 8 a.m. on a Saturday. Glad to have you here. All right. So when I ask that question to the thousands of people, what do you want to make sure we talk about? I usually hear one of 8 different things, maybe one of 9. I'll say that because sometimes this kind of bonus one, or this one that's not included in the 8, I'll call it the 9th one, is Paul, we don't really know we don't know enough to know what to be concerned about. We just know we've never done anything, and we know we need to get some legal affairs in order. So here we are. And so when people tell me that they don't even really know enough to know what they should worry about, then, I'll give them the buffet of the 8, and then they'll start saying, well, that one we're worried about, that one not so much, that's a big one. And then we go from there. So the 8 typical answers to what do you want to make sure you accomplish when you put an estate legal program in order. One is kind of maybe the obvious one. We want to make sure that the distribution of our estate is the way we'd want it to be. So people have different opinions on how what they've saved and what they've accumulated is to be dispersed to their family. Let me give you some examples. The kind of default might be, we have 3 children. We, whether it's a single person, married couple, whatever the case may be, when we pass away, we want everything to go to our 3 children equally. Many, many people just say that, our kids equally, and that's their distribution schedule, and I can't argue with it. Nothing wrong with that there. But then there's another group of people that wants to be a little more specific, anywhere from, no, let's provide something for each of our grandchildren to let them get, a head start on life or an education, and then let's leave the rest to our children. Or some people will say, we want to leave our home to our daughter because she struggles, she doesn't have a home. Our other 2 children, they're doing well, they have a home of their own. Let's leave our home to our daughter and then leave the money equally to our kids or to grandkids, or the one who gets the home may get less money because the one who got the home. So all of those are part of the kind of distribution schedule. Occasionally we have people wanting to leave bequests to charity or charities. Had a gentleman this past week, his wife passed away from a certain illness, so he wants to give $5,000 to that particular charity that supports that illness. Some people give to their church, some people give to their school or college. But I would say, in general, if there's one distribution schedule that's most common for people who have kids, it's leave it to the kids equally. So anyway, that's one objection that people have, is getting that distribution schedule right. I will also say, as far as the distribution schedule, part of that discussion is, yes, I want to leave it to my 3 children equally. And quite frankly, I had this discussion yesterday with a woman, 2 children, and I don't want to get into the details too much, but the way that woman's distribution schedule was, I want to leave half of what I have to my child number 1, but what I leave to child number 2, if I left it what I call outright to child number 2, that money would be gone in 6 months. So part of the distribution schedule is just determining whether things can be left what I call outright. You give it to them when you die, it's theirs, they do what they want to with it, versus leaving things in a trust for child B, where child B cannot blow it, and maybe child A or some other person is the trustee over the child B trust, and child A can determine what are appropriate expenditures for child B, and spend the money for child B, give the money to child B based on child A's authority to make those distributions. Okay, so that's part of that distribution schedule. That's just one of the objectives that people have. A second objective that people have is, sometimes people say, you know what, Paul, when my mother passed away, it seemed to just take a long time. It was very expensive. We had to go through the courts. We had to hire lawyers. If there's a way that we can simplify that and not have my survivors go through a bunch of red tape with court and attorney involvement, I'd like to simplify my estate settlement. That also a very common objective. So digging in that one a little bit, when you pass away with assets in your name, unless they're things like an IRA or life insurance where you've designated beneficiaries, then those assets are frozen. Your survivors have to hire lawyers like myself, and it's just the way the system is. Our court system is responsible for overseeing the administration and settlement and distribution of your estate to your heirs, and many people perceive that court and attorney involved probate process as being overly time consuming and overly expensive, and they probably perceive it that way because in many cases it quite frankly is. And so what we do for a lot of folks is arrange what they have in a way so they still control it, they do whatever they want to with it while they're alive, but when they die, nothing gets frozen, nothing has to go through the court system. Lawyers often don't need to be involved. Maybe a family member is the trustee of what I'll call that family trust or that living trust. The day after dad dies, son, who is the successor trustee of the trust when dad dies, he's the one in charge, he can immediately access accounts, sell property if that's what's appropriate, and divvy things up appropriately in accordance with the instructions in the trust instrument, but without having to go through all that court and attorney involvement. So simplifying the estate settlement is my second objective that we get to. The third one is simply avoiding your state's plan. Because if you don't have a plan, your state has a plan. I know here in Louisiana, when someone dies without a will, the laws, when somebody dies without a will, they're deemed to have died intestate. If they had a will, they're deemed to have died testate. So I know Louisiana's intake laws, particularly with married couples, when a married person dies, those laws that govern who gets the stuff in absence of other legal documentation really kind of sell the surviving spouse short. the laws really favor the children, the grandchildren. They don't do much for the surviving spouse. So many married couples, when they come into their office, my office, they're like, I realize, if I were to pass away without a will, my wife, my husband, she can't even sell our home without going and getting our children's permission. I don't want that to be the case. I want to give my spouse more control than the intestate laws provide. So for some, it's avoiding the estate's plan. Number 4 is the answer of something like, Paul, we want the least amount of tax burden on my survivors when I pass away. I've paid tax all my life. I've paid income tax. I've paid capital gains tax. I hear there's this estate and gift tax. I want to avoid tax, avoid tax, avoid tax. So then it often is not so much a discussion about the federal estate tax, which only applies when people have more than $11.58 million in assets when they die, which most people don't. But there are significant capital gains tax and income tax consequences to how you leave things and how much tax your survivors and when they'll have to pay that tax on things like your traditional IRAs and on the sale of your home and on the sale of other investments that you may have. There's those, capital gains tax and income tax laws are triggered, and things can be arranged as part of an overall estate planning legal program so that those taxes are either minimized or, quite frankly, completely avoided. And we'll have one of our 19 presentations, our federal estate tax law, which I mentioned very quickly, exempts the first $11.5 million. 2026 and beyond, they're going to cut that figure in half. Still, you got to have a big chunk of change to be exempt or to be subject to the federal estate tax in 2026 and beyond. It's going to be around $6 million, but it's going to come bite some people in the behind as we saw stock market yesterday go up, percentage points. So anyway, there's some things that can be done now to avoid that potential future estate tax in 2026 and beyond, because I would bet most of the people watching this video are still going to be alive in 2026 and beyond. No guarantees there. All right, so that's number 4. Number 5 reason people put an estate legal program in order is they want to put the right people in charge. There are many designations that one makes when they put their estate legal program in order. So things like who do you want having the ability to talk to your doctors? Let's say you're in a surgery or you start getting demented and you're not able to make your medical decisions. Most people want to designate who has the right to make those decisions on their behalf. If you're married, you'll probably appoint your spouse. If you are not married, or if you don't want your spouse, maybe an adult child or children, but it makes it much easier for them to talk to your doctors, access your medical records, deal with your medicines if you've put those plans in place and made those designations. Another designation is who do you want handling all of your money and all of your business if you, at some point during the rest of your lifetime, become incapacitated. Again, you get demented, you have a stroke, you're not able to pay your bills, sign your checks, deal with your taxes, deal with other government organizations. By doing a lot of these durable financial powers of attorney, you can make it real simple for the trusted, probably family members that you select to be able to do all of that stuff for you without a bunch of court and lawyer involvement. So that's another designation. Then there's the who's in charge when you die designation. Yes, you may through your governing legal instruments, as we said before, determine the distribution of your estate, but you'll also designate either an executor or a executor of your will or a trustee of your trust. More on that in 2 days on this will or trust YouTube live presentation that I'll do on Monday. But you'll be making executor and trustee designations. Really, really important designations. Having the right people do that can make things go smooth. Having the wrong people do that, complete disaster and utter nightmare. So those are other designations of making sure, who's going to handle things for you at the appropriate time while you're alive, medical, financial, and then who's going to handle the distribution when you pass away. Could be one person, could be multiple people together. And then if you do designate multiple people, how many of them have to get together to agree to act? All those are important decisions. So putting the right people in charge is, I think, number 5. Number 6 is, is number 6 as a number 5. So let me go on to the next one, because they were the same thing. I just worded it differently. Other people, this gets a little in depth, and it's often not, well, no, it often is the first words out of people's mouth, which I heard yesterday was, Paul, we want to make sure, and they'll say it different ways. Sometimes they're trying to be kind of polite in their words, and sometimes they're very blunt. I get it either way, and either way is okay. But this is the Paul, I want to keep things in the bloodlines. That's the kind of polite way to say it. And then people might get a little more to the point. Paul, our son-in-law is very controlling over our daughter, and he really likes to spend money. He spends a lot of money that he doesn't have. I don't want to leave my inheritance to my daughter in a way that my son-in-law can control it and go spend it, and he winds up with all of the inheritance. I don't want to do that. I want to protect it for my daughter. So that's the whole making it kind of divorce proof. And again, a state law issue, but let's say mom and dad die, they leave $500,000 to their daughter. The daughter has a very influential husband, and he spends money. He tells his wife what to do, and she does it because she doesn't want to disrupt the marriage. And so when the daughter gets it, it's her money. But first thing they do, they put it in a joint account, mix it with maybe a few other dollars that they have. Now it's owned by both of them. And maybe it could go on to the next step when now the husband starts spending and spending and spending. And next thing you know, he's spent all of it. None of it's protected for the daughter. Or maybe they get married, and because, the inherited money was mixed up with other money that the two of them had, they wind up having to split the money upon the divorce. So a lot of issues out there on the making our children's inheritance divorce proof. And then a final common, just getting started right out of the box, what concerns you, answer, and this is a big one. This is a really big one, in fact, I may hear this answer more than I hear any of the other 6 or 7 answers combined. But these days, when I ask, what do you want to make sure happens, and this again is one of those issues where people will kind of dance around it because they don't want to be blunt, or in fact, most people dance around it. And I'll ask them, what do you want to make sure we accomplish? And they'll start with, well, we want to protect our money. And I know what they're getting at, but I want to hear them say it. And so, and then I'll be like, well, when you say you want to protect it, what do you want to protect it from? And then they'll say, well, my mother was in the nursing home, and we have a history of dementia in the family, and I don't know if I'm going to get sick. I just want to protect my money. And so again, what do you want to protect it from? And then finally I get out, well, if I gotta get sick, and that, I don't think people like to admit that they might need nursing home care in the future because there's such a bad rap, probably justifiably so, on nursing home care, that people just don't like to admit it, that it might be a necessity in the future. Some people will admit it. Some people say, look, I don't like nursing homes, but I don't want to go move in with my kids, and I don't want to burden them. And so if I got to go to a nursing home, I got to go to a nursing home. But I want to make sure that what we have is protected, because most people understand the rules about if you go into a nursing home and you have any assets in your name, you have to spend all of your assets. The nursing home care, depending upon your state, depending upon the facility, maybe it's $6,000 a month, maybe it's $10,000 a month, but you got to spend your own resources until you have less than $2,000 remaining. So many people want to structure what they have now so that in the future, if they go into a nursing home, all of their assets are protected and they don't have to consume them. They qualify for that long-term care Medicaid immediately. So that's a big one here, and we're going to have 2 or 3 of the next, 19 presentations are all about that. What can you do to protect your estate? What can you do to protect the home? What are the specific 2020 rules that change every year regarding long-term care Medicaid eligibility? Those are all deep dives that we'll be doing over the next 19 days. So for starters, those are a lot of the issues. Rather than just tell you, and estate planning is writing a will, it's writing a trust, it's writing a power of attorney. Hogwash, that's all. I don't want to get into the legal mumbo jumbo. I want to get into the what are people worried about, and then how we can address those concerns. Okay, so going back, because I want to catch all, we've got New York here on the call from T. Mitch. Paul, I heard you talk on probate before. I'm in New York. Father-in-law passed, only house is in his name. Is there a simple probate in this situation? So great question, T. Mitch. Father-in-law died. All he has in his name is the house. We talked a little bit about how probate courts, lawyer involvement can be challenging. So is there any recourse for T. Mitch and I guess his wife? Really, that's a state issue. I will tell you, in Louisiana, if somebody dies and the value of what they have is worth less than, I think it's $150,000 or $125,000, and they have no will, and then the family can do this, what's called small succession affidavit, and it's a simpler way to get a very small estate passed along to the survivors outside of a full-blown court-involved matter. I don't know if you have that in New York, and I know in Louisiana it's only permissible when someone doesn't have a will, because if they do have a will, then you got to go through the court process to have a judge validate the will. So it's one though that you've got to check on kind of from state to state. May want to look up. I bet if you looked up and asked Mr. Google that question, you could probably get an answer from some New York estate lawyer who may have kind of written a blog post or made a video on that subject matter. So good luck there, T. Mitch. All right, great question. So far, that's the question of the day, and it's really kind of the only question of the day. So you're at the top. Okay, so now what I want to do is take a quick, if you've seen the schedule of upcoming presentations, you know what those titles are, and I just want to give you maybe an extra little kind of few bonus points about each of those upcoming 19 topics to just maybe whet your appetite. So you can really determine which of the 19 that that you'd want to be involved on. Good morning to you, A. Prandl. You win the Good Morning Award because there's 3 of you have said good morning. So, okay. All right. Let me check with Amuse. For those of us that want to leave wealth for more than just a generation trust, do we ask lawyers to administer fiduciary? Very, very good question. And so I'm in the question answering mode this morning because this is just, I'm touching on a bunch of stuff and I want to get questions answered. All right. So let me kind of guess at what you're getting at, but you did a good job. But for those of us that want to leave wealth for more than just a generation in trust, so I'm guessing that you not only want to maybe help your children, but you also want to help your grandchildren, maybe even future great grandchildren. Do we ask lawyers to administer fiduciary advisors? Family members are not going to be able to manage it. That's a tough one because these are things that may be in effect for many, many years. So let me touch on some of the issues. I had a gentleman 2 weeks ago, and he didn't have any children. His deceased wife had a little bit of family, and so he didn't feel comfortable designating his wife's family, who he kind of felt were not real savvy, and to be handling, his money. So he was like, Paul, you're a lawyer. Can I appoint you to handle things at different times in the future? And I'll be the first to admit that is a rare request. Many times people, they designate their children as being in charge of these family trusts. But you're talking about perhaps a trust that could go on literally for generations. So I would say asking lawyers to administer, that would not be my first get. Lawyers are in the business of being lawyers. Lawyers typically aren't in the business of being, trustees and executors and playing these roles where they have, fiduciary responsibilities to beneficiaries. I know I'm much more comfortable with my, lawyer hat on, and I'm often the lawyer for that trustee, for that executor, for that person who has power of attorney, and we can make their life very, very easy. But I'm much more comfortable in the lawyer role advising those people rather than actually being in that role. Okay, so it's a tough one, and just to get to the straight bottom line, what we often do is parents who want to leave some multi-generational program in place to benefit their children, benefit their grandchildren, perhaps even their great-grandchildren, maybe even beyond that, depending on how old this individual or couple may be. They seem to be comfortable saying, when we die, maybe they'll have one or more of their children that they feel comfortable kind of taking over. But those children are only going to last so long. So often what we do is we put in place a person or people who, in the absence of a fiduciary, trustee, executor, whatever the case may be, typically trustee, then it might say, when after we die, meaning old man and woman, child number one will oversee this multi-generational arrangement that we have when we are gone. And then when child number one can no longer oversee this, then it might say, this is just kind of throwing ideas out there, it might say that our adult grandchildren can collectively designate the next trustee or person to be involved. And sometimes people like that because those grandchildren, they have an interest in finding someone capable because they are beneficiaries of this arrangement. So I would say lawyers are typically not the first person to select to administer. Family members are, responsible, mature, organized family members who have good relationships with other family members. That can be ideal. When you talk a fairly significant amount of wealth or assets or investments, you could select the appropriate kind of large bank trust company that will be the trustee to oversee this and will likely be around for generations. Or they'll merge into some other company that will be able to handle it for generations. So that's just some of the, how do we designate people to administer something that we want to stay in our family for generations. Hope that helps. Feel free to give me some feedback. All right. Can I leave my single member PLLC, which I'm pretty sure stands for Professional Limited Liability Company, law firm, to my non-lawyer spouse in a trust or will? Great question. And I'm going to kind of guess because I don't know that I've ever been asked that question, but I think what would happen is if, because it's my arrangement. I mean, you're asking a question of me, I'm a lawyer. My wife is not a lawyer. And so, yes, I feel certain you can leave that entity to a non-lawyer. Of course, that non-lawyer cannot practice law, but those assets of the company then are owned, by that LLC, which is owned by that non-family member or non-lawyer. If there's some opportunity for the non-lawyer to, sell the law firm to another, that is permissible, out of an estate or out of a trust. But I know, I have handled many where survivors have had to wrap up the business of a professional organization like that. And there's no prohibition on that. Of course, they just can't be that doctor or lawyer. So I hope that helps. It's kind of a vague answer. I didn't really just nail it for you, but I did the best I could. Okay. They may be the way I have to go. No kids, so maybe like a D.A. Davidson or something. I'm not even sure what you mean by D.A. Davidson. So there we go. All right. Here's the deal. So now I'm going to jump in and give you a quick, real fast overview of, and oh, by the way, a couple things. I might kind of give you some insight into the next 19, and I'm going to give you some good stuff. But those of you who are watching, smash the like button. That tells YouTube, show this to a few folks, more people. That'd be the one thing I would ask of you, or maybe two things. One is, since I've got 19 more, you probably have some, I don't know YouTube real good, but you probably have some share button. And if you could share some of this stuff with your friends, your colleagues, your relatives, people who you think may have an estate and are kind of worried about how to leave it to their spouse, to their kids, just share it with as many people as you can. We're going to be doing this for 19 more days. So when you can share, great. And again, smash the like button. I see we got 12. Let's get it up to 13. Do I hear 13? I want to smash the like button. Give me 13 and we'll go on to 19 more topics. Okay, so here we go. Oh, 14, even better. All right, so hey, life is good. It's the little things, folks. It's that it makes us whatever happy. Here we go. No particular order. No, actually in chronological order of the next 19 YouTube live presentations. And really, I'm going to tell you what the topic is, but then I'm going to give you maybe 3 really important bullet points so that you'll know whether to tune in, or you'll know why you should tune in. All right, so tomorrow is the will or trust analysis. So in many states, California, you're on the call, you're on the presentation. Florida, don't know if you're on the presentation. There's some states out there where probate is an absolute nightmare. It's kind of a no-brainer. Let's do whatever we got to do to avoid probate, because probate, it takes years. It costs tens of thousands of dollars. It's just a nightmare. In those states, it's kind of a no-brainer. No, let's not have a will and leave everything in our name, so that when we die, all of our assets are frozen. Our survivors will hire lawyers to go through the court process, where judges will have to get involved to sign court orders ordering that assets be transferred out of our name and into the names of the heirs. That'll take years. No, let's set up what we call a living trust. And let's title assets that we own from John and Jane Smith to John and Jane Smith as trustees of the John and Jane Smith Living Trust. Then when we die, we've designated in the trust our son Timothy to be the trustee. We've designated our 3 children as the beneficiaries of our trust to receive the trust assets when the 3 of us die. And when we die, the next day, Timothy has access and he can disperse everything to the 3 children equally. No courts or lawyers are involved. So we're going to take a closer look at that will or trust analysis, pros and cons, getting it set in this earlier. Looks like we might be having some unstable internet connections. If we do, we pick up tomorrow where we left off. And anyway, that seems to happen some with YouTube Live. The next day, protect assets from nursing home expenses. If you're part of that middle class and you are worried that one day you might have to go to a nursing home, who knows, you need to watch that YouTube Live presentation, because you need to take action at least 5 years before you ever even think about stepping foot in a nursing home. So that's why planning ahead is the key to making it easy to protect what you have. Then on June 9th, it's all about what, you hear the words avoid probate a lot. And so June 9th is really, what does it mean to avoid probate? Deep dive there. June 10th, big one here, real big one. Naming beneficiaries of your IRA accounts. Some laws changed on January 1st of 2020, significant law change. So there's new decisions that people have to make when they designate their beneficiaries of their IRAs. I know the traditional customary way to do it, if you're married, is you name your spouse as your primary beneficiary, you name your kids as your secondary or contingent beneficiaries. Some people, however, need or want to name a trust as a beneficiary of an IRA. all those rules have changed. We'll take a deep dive into naming beneficiaries of your IRA on June 10th, June 11th. The issue I talked about earlier, protecting your children's inheritance from their divorce. Most people don't even think about that. And then once it's presented to them, they feel very passionate about it. Yes, Paul, we want those extra protections in place so that our children's inheritance belongs to our children for the rest of their lives, even if they get divorced or their spouse influences them or whatever. We want to protect it for the children. That is on June 11th. June 12th, here's a Louisiana. June 12th is all about the Louisiana usufruct. If you're outside of Louisiana, you've probably never heard of the word usufruct. If you're in Louisiana, you probably have heard it because it is a form of ownership that is exclusive to Louisiana, where when a married person dies, often the usufruct, which is a form of ownership, is left to their spouse. Kind of similar to what other states have in a life estate, but we'll dig into what usufruct is on June 12th. June 13th, how to complete a probate. And so, and oh, by the way, I'm Shrestha, got it, Shrestha, what a name. I will be live every day, 10 a.m. Central Time, next 19 days. And in particular, on June 13th at 10 a.m. Central Time, I'll be talking about how to complete a probate. I bet you know somebody who has complained to you about a probate. Paul, it seemed to take forever. Paul, it took a year and a half. Paul, the lawyer didn't do what he said he was going to do. Paul, the lawyer dragged his feet. Paul, paperwork just got, sat on a judge's desk at the courthouse for what seemed like months and nothing ever got done. All the financial institutions, lawyers where my parents had accounts, they dragged on forever. Paul, the executor, I don't know what they're doing and they're not communicating well and we're having to force them and hire lawyers to get them to do their job. So we'll talk about how to complete a probate as quickly and efficiently as possible so that people don't end up waging war against each other. That's June 13th. June 14th, in 25 or 26 states, you can actually handwrite your own will. Lately, with the coronavirus and people staying at home, quite frankly, and bluntly, old people staying at home and who hadn't taken care of any of this stuff, they got worried because they weren't leaving their house. They certainly weren't going to go to a lawyer's office. By the way, here it is, June 6th. I haven't had a new client meet me in my law office since before March. You might think, Paul, that's a disaster. But amazingly, all these people who kind of refused to do business by phone before are now insisting on doing business by phone, which is great for me. I'm in my home. I can work from home. It's efficient. We've had a number of clients come into our office, mask on, to sign their documents. They come in, social distance, sign, they leave, they're there 5 minutes. But the initial, Paul, I think I need to talk to you about putting a legal program in place. That's all been by phone since early March. And what I see is kind of maybe a gradual shifting of kind of a lot of people still wanting to do it from home. By the way, if you live in Louisiana or have the Louisiana connections and you feel like you'd like to have a discussion, you can go to my website, RabalaiSestatePlanning.com, click on a button. It takes you to my calendar and you can block off a 15-minute kind of free phone call where we can just initiate a discussion about your particular needs. Going back to June 14th, like I said, 25, 26 states permit its residents to have a handwritten will, which came in handy for some folks in the last 3 months who didn't want to get out, didn't want to get in the presence of lawyers and notaries and witnesses. So in those states, it's pretty easy to make a valid will, but the content of it is what messes people up. So on June 14th, we'll talk about not only how to meet the validity requirements, but how to make sure it accomplishes what you need it to accomplish. Then on June 15th, if you have a home and if you go into a nursing home and if you use Medicaid dollars and you own that home when you die, then Medicaid, depending upon your state and what your state's rules are, can exercise its estate recovery rights to force the sale of your home after you die to pay Medicaid back for what Medicaid spent on your nursing home care while you lived in a nursing home as a Medicaid recipient. So if that happens, then your children or your heirs get no benefit from your home. We'll talk about the different strategies available to protect the homes so that that estate recovery does not occur when you pass away. All right, so that's June 15th. June 16th, avoiding the federal estate tax. I mentioned earlier on January 1st of 2026, we've got all new estate tax laws. Many of you watching this are going to be around then. Some of you who are not subject to the estate tax now will be subject to the estate tax in 2026. Pay attention for that on June 16th. June 17th, kind of a question I get all the time. Paul, what's the difference between a revocable trust and an irrevocable trust? So since we get that question so much, I said, well, let me do a YouTube live presentation on that. And I'll be diving into how, and this is generally speaking, many individuals and couples will take advantage of the benefits and the features of a revocable trust, starts with the letter R, in order to maintain complete control over what they have for the rest of their lifetime, but make it easier for their survivors to get it when they die, versus people creating what's called an irrevocable trust because they want to maintain some control, but they need to get assets kind of out of their name for some reason. That might be avoiding estate tax, it might be avoiding nursing home costs, it might be avoiding lawsuit judgments against you, or it could be for a number of other reasons that we'll get into on June 17th when we answer the question, what's the difference between a revocable and an irrevocable trust? A lot of issues that I'll be talking about on June 18th about the power of attorney. It's often kind of an afterthought when people put their legal program in order because they're worried about all the other stuff. But a lot of power of attorney issues are popping up these days because people are signing powers of attorney. They're appointing people to handle their affairs. Those people who are signing the powers of attorney, years later, they're becoming incompetent, incapacitated. And here comes that person handling either the right way or the wrong way, handling your assets. And that can create a lot of trouble. We'll be talking about June 18th. June 19th, mentioned it just a moment ago, protecting your estate from lawsuits. Most people start this discussion when it's too late. Paul, I got in a bad car wreck and I was determined at fault. Yes, I have car insurance, but the damage was really significant. Or, Paul, I own a business, and because of A and B and C, I think I might get sued, and I want to protect what I have. So better to know how all of that works before an incident occurs, because when an incident occurs, even though a lawsuit has not been filed against you, it may be too late to protect what you have. Stay tuned on June 19th. June 20th, a lot of online legal programs out there. The elephant in the room, because they do a lot of advertising, they're big, quite frankly, is LegalZoom. I have had a couple of inquiries lately about the LegalZoom will, the LegalZoom trust, the LegalZoom LLC, the LegalZoom power of attorney. I'm going to go over some really important points there on June 20th. Only 5 left, June 21st. People want to know, Paul, how can I structure my account at the bank so that when I pass away, my husband, wife, daughter, son, children have access to my bank account? I don't want it frozen. They're going to have to pay for my funeral, and there's going to be other expenses. I don't want them to have to, use their own funds for that. What can I do to avoid my bank accounts being frozen? All about that on June 21st. June 22nd, Paul, what does it mean to fund a trust? So a lot of people look into the creation of a trust, and then they hear that their trust should be funded. What does that mean? What is the retitling of assets into a trust? How does that go? Why is it necessary? We'll talk about trust funding on June 22nd, June 23rd. I get this question a lot. Paul, when somebody sets up a trust, dies, what happens? And so we'll get into, well, what do the terms of that trust provide? And what often happens when someone who sets up a trust dies? Who gets control? What do they do? What are their responsibilities? What are the beneficiaries' rights? So we'll get into all of that June 23rd. June 24th is the 2020 rules for long-term care Medicaid. Married, what happens if a single person goes into a nursing home? What if a married couple together goes into a nursing home? What if you have a married couple and one of them goes into a nursing home and one of them still stays at home? So there's different asset and income rules that apply to all of those situations. I'll lay that out for you on June 24th. And then June 25th, I'm just going to go kind of rehash the 5 main mistakes that people make when they put their estate planning, legal affairs in order. All right, so we're about to wrap up here. If you have a joke, a comment, a question, the rest of our time, and the rest of our time might be 15 seconds, or the rest of our time might be 45 minutes, based on any questions you might have. It's okay if you don't have any. Do encourage you to not only click the like button, but there's likely a subscribe, a red subscribe button. That puts you among the elite 6,000 or so other people who have subscribed to my YouTube channel called Rabalais Estate Planning LLC. And that way you won't miss anything as I put out new content. And as you get on YouTube's website, YouTube will at least let you know or indicate you that I've put out new material. So it's real important that you subscribe and hit the notification bell so you don't miss anything. All right, so you're welcome, A. Prandtl, for all of the information. Stay tuned tomorrow morning, 10 a.m. There'll be a joke of the day up there. If you want to provide an extra joke, that would be phenomenal. You'll get bonus points for that. Y'all have a great, I feel like I'm taking a master class in adulthood. Thank you so much. You made my day, Mr. or Ms. A Muse in the craft room, whatever that means. I get a kick out of some of these names on YouTube. But thank you so much. Y'all have a great day. By the way, if you want to schedule a time where we could talk next week, go to our website, click on the schedule a call button. You'll see my calendar, schedule a free 15-minute call. I'll call you precisely at the time that's scheduled, and we'll go from there. Y'all have a great day. And you're welcome, Bella Vista Web, who says thank you. Thank you for your very informative information. And you're welcome. See you tomorrow.